questions to all of you. Judge Sykes, do you think America is mostly good or mostly bad?
Senator Kennedy, I think America is mostly good.
Thank you. How about you, Counselor Roshan?
I agree. I think it's mostly good.
Good. How about you, Judge?
Mostly good, Senator.
Okay, thank you. I'll start back here again. Judge Sykes, tell me about, tell me what the Dobert, some say Dobert, some say Dobert. I'm from Louisiana, so sometimes we say Dobert. Tell me what the Dobert or Dobert standard is.
Senator Kennedy, in my 8 years of practice as a Superior Court judge and presiding in the state of California, I have not had occasion to hear that the Dobert. So I can assure you, though, that I have had occasion where in a civil matter, I may not have known something, and I do the research necessary to discover and to research whatever it is that I need to do to make myself familiar with that. So I can assure you that in this case, I would do the same.
So you'll look it up?
Yes, Senator, I would do whatever it takes to make myself familiar with that and be prepared to go forward.
All right, can you tell me?
The U.S. Senate confirmation hearings often reveal not just the qualifications of judicial nominees, but also their ability to think under pressure. In a recent exchange, Senator John Kennedy of Louisiana questioned several nominees on America's character, legal standards, and judicial principles. What followed was a revealing moment that shed light on both the senator's style of questioning and the nominee's readiness to serve on the federal bench. The hearing began with a straightforward but symbolic question. Is America mostly good or mostly bad? Judge Sykes responded confidently, mostly good. Counselor Roshan agreed, affirming America's overall goodness. Another nominee echoed the same sentiment. This line of questioning, while simple, served as a litmus test of perspective and patriotism qualities often scrutinized in judicial nominees. Senator Kennedy then shifted gears. Kennedy tested the nominee's understanding of the balance between federal and state authority. He asked for an example where a federal judge would apply federal procedural law, but state substantive law. Though unable to cite an immediate case, Judge Sykes referenced the Erie Doctrine, a foundational principle that guides federal courts in diversity jurisdiction cases. This showed familiarity with doctrine, though not with a concrete example, a nuance that did not go unnoticed. In a lighter but telling moment, Senator Kennedy misstated Judge Sykes's nomination as being for the Southern District of New York. And
As a federal judge, give me an instance where you will apply federal procedural law, but state substantive law.
Thank you, Senator, for that question. In regards to an instance, I cannot think of an instance off the top of my head, but I am familiar with the Erie Doctrine, which guides that process. And the Erie Doctrine does require that.
What's it say? Yeah, I'm sorry, go ahead.
Sorry. The Erie Doctrine does require that I would follow federal procedural law and state substantive law.
Okay. You're nominated for Judge Southern District of New York?
No, Senator. I'm nominated for the Central District of California.
Oh, okay. I apologize. Let me.
critical, the hearings also test resilience, adaptability, and the ability to handle scrutiny. For nominees like Judge Sykes, every answer shapes not only their confirmation prospects, but also the public's trust in the judiciary. If you enjoyed this breakdown, don't forget to like, comment, and hit the subscriber button for more political showdown.